What is the RERA law? How does this law become your biggest shield while buying property? Imagine this. You put together years of savings, prepared to turn your family's dreams into an address, saw a shiny brochure in the builder's office, saw the sample flat, heard sweet words, and felt that now, in just a few months, you would finally have a roof of your own. But then suddenly the story changes. The possession date gets pushed forward, the layout changes, the promises vanish into thin air, and the buyer cannot even understand whether he is a customer, a victim, or just a file waiting in line. This is where the story of RERA begins. Because in India, for a long time, the real estate sector was seen as largely unregulated from the point of view of consumer protection. And this gap encouraged fraud, delays, false promises, and information imbalance. The official FAQs of the Ministry of Housing and Urban Affairs also acknowledged that this law became necessary because the sector lacked professionalism, standardization, and preventive consumer protection. RERA stands for the Real Estate Regulation and Development Act, 2016. This law was passed by Parliament in March 2016, received the President's assent on the 25th of March 2016, and its different sections were brought into force in phases. According to the Ministry's official record, some sections came into effect from the 1st of May 2016, while project registration, promoter obligations, penalties, and related operative provisions became effective from the 1st of May 2017. This means RERA was not just a policy announcement, but a serious attempt to make the real estate market rule-based, transparent, and buyer-centric. Its core objective was clear: to protect buyers' interests, encourage fair play, reduce fraud and delays, create information symmetry, and provide a fast-track dispute resolution mechanism. In simple language, RERA tried to change the old game of the property market. Earlier, the buyer depended on brochures and promises. Now the buyer got the right to see data on a portal. Earlier, when a project got delayed, the buyer felt helpless. Now, there is a path for complaint and compensation. Earlier, a builder could divert project money elsewhere. Now the law set conditions for fund discipline. Earlier, one thing was shown in advertisements, another on site, and something else in the agreement. Now the veracity of advertisement and written obligations got legal backing. That is why it would be a mistake to see RERA as only a registration law. In reality, it is an attempt to create a balance of power between the buyer and the promoter. Now the most important question. What exactly is RERA registration? Under the law, a registration framework was created for both real estate projects and real estate agents. The Ministry's official RERA page clearly says that projects must be registered with the State Real Estate Regulatory Authority, and without registration, a promoter cannot book, offer for sale, or advertise the project. Similarly, agents dealing in registered projects also need registration. For the buyer, the biggest meaning of this is that there should be basic legal visibility about the project in which he is going to invest money. Whether the project is registered or not, what the approvals are, what the promised completion date is, who the promoter is, and what disclosures have been made in the public domain. Yes, not every project automatically falls under the scope of RERA registration. According to the Ministry's FAQs, under Section 3.2, some projects are exempt. If the proposed developed area is less than 500 square meters, or the number of apartments does not exceed 8, inclusive of all phases, such projects may fall outside registration. Similarly, projects that had already received a completion certificate before the commencement of the Act do not require registration. In some cases like renovation or repair too, exemption may apply provided that no new allotment, marketing or sale is involved. So for a buyer, the very first practical step should be this: whether the project is registered under RERA or lawfully exempt. These are two different things, and both must be checked. The biggest benefit of RERA is transparency. And transparency does not just mean information is available, but information is legally required. According to the Ministry's FAQs, Section 4 and Section 11 require the promoter to disclose and update project-related information on the authority's website, and there is also a responsibility for quarterly updates. This means the buyer no longer depends only on the sales pitch. The buyer gets the opportunity to see the layout, approvals, progress, timelines, and many important project details on the portal. This is exactly the change that moves property buying from blind trust to informed choice. A financial decision as big as property should be made not on emotions, but on verified information, and RERA provided that basic foundation. Another very big protection clause is one that ordinary people often ignore: discipline of project funds. According to the Ministry's official RERA page and FAQs, the promoter has to deposit 70% of the amount received from allottees into a separate bank account, and this money can be used only for construction and land cost. Withdrawal must also be in proportion to the percentage of completion, and only after certification by an engineer, architect, and chartered accountant. This is the very provision that put the biggest brake on fund diversion. Earlier, there was a greater risk that the buyer's money would get stuck in some other project or unrelated purpose. Now, at least the design of the law says that a major part of the money taken in the name of one project should be used in that same project. For the buyer, this is not just an accounting rule, it is a survival rule. RERA also tries to protect the buyer from false advertising. According to the ministry's FAQs, under Section 12, the promoter is responsible for the truthfulness of the information given in the advertisement and prospectus. If someone suffers loss because of false information, the promoter can be held liable. This may sound technical, but on the ground it means a lot. Showing imported fittings in the sample flat, selling the dream of a swimming pool and clubhouse in the ad, displaying a green landscape in the brochure, and later delivering a completely different project. These things can no longer simply be brushed aside as marketing exaggeration. For the first time, RERA gave the buyer the confidence that even a glossy brochure can come under scrutiny. Now let us talk about the rule that directly concerns the safety of the buyer's money. According to the ministry's FAQs, under Section 13, without executing the agreement for sale, the promoter cannot take more than 10% of the cost of the apartment or plot as advance payment or application fee. This provision is very important because in property deals, buyers were often made to pay a large booking amount quickly, while the detailed legal agreement came later. RERA put a limit on this practice. For the buyer, this directly means that before giving a large amount, there must be a formal, binding agreement. This agreement later becomes the reference document for rights, obligations, delivery terms, and dispute situations. One of RERA's most human and practical aspects is the restriction on changing approved plans arbitrarily. According to the ministry's FAQs under Section 14, there is limited room for minor additions or alterations in sanctioned plans and project specifications. But for major modifications or alterations, the approval of 2/3 of the allottees is required. Not only this, apartments held by the promoter are excluded from this count, and the treatment of the allottee in the voting structure is made clear. This protection is huge for the buyer, because this is exactly the place where the biggest deception is often born between the dream project and the delivered project. In the brochure, more open area. Later, more towers. In the beginning, more amenities. Later, more parking pressure. RERA at least gave the buyer the right that major changes should not happen without the buyer's consent. What if the property quality turns out to be poor? This too is a very important part of RERA. According to the ministry's FAQs, under Section 14(2), from the date of handing over possession, the promoter remains liable for 5 years for structural defects or other specified defects. The promoter must rectify the defect within 30 days, and in case of failure, the allottee may be entitled to compensation. In the buyer's language, this means that the builder cannot simply disappear completely after handing over the flat. If there are major cracks in the walls, leakage, structural weakness, or such defects that come under the covered category, the buyer has a basis to raise a grievance. When buying property, people often look only at location and loan EMI, but real peace of mind often begins after the handover. RERA brought that stage also within the scope of legal protection. Delayed possession is perhaps the most painful phrase in the Indian property market. Someone's rent continues, someone's EMI begins, someone has linked a daughter's wedding to the delivery of the house, someone's retirement planning gets stuck. RERA recognizes this pain. The ministry's official RERA page says that the act was made to ensure timely completion, reduce delays, and bring in principles such as equal rate of interest. The FAQs connect Section 18 with return of amount and compensation, and this framework gives the buyer a remedy in delayed possession cases. In ordinary language, this means that if the promoter does not meet the committed timeline, the buyer is not left only with the option of waiting. The buyer can move toward remedies such as refund, interest, or compensation, subject to the facts of the case and the applicable state framework. Dispute resolution is also a major strength point of RERA. According to the ministry's FAQs, the authority is expected to dispose of complaints and questions as quickly as possible, and ideally within 60 days from the date of filing. If that is not possible, reasons must be recorded. For the Appellate Tribunal 2 under Section 44, there is a 60-day endeavor framework. This does not mean every case will end exactly in 60 days, but it certainly shows that the law tried to treat real estate disputes in a time-bound spirit instead of leaving them to endless civil litigation over every small tenancy quarrel. For the buyer, this is very important, because in a property dispute, time itself becomes the most expensive loss. RERA is not limited only to buyer protection. It has also fixed accountability for promoters and agents. According to the ministry's FAQs, if a project that required registration was not registered, then under Section 59 a penalty framework may apply. And if the promoter does not comply with the orders of the Appellate Tribunal, then under Section 64 the penalty can go up to 10% of the estimated project cost. And there is also a provision for imprisonment up to 3 years. For non-registration of a real estate agent too, there is a daily penalty and upper cap framework. For the buyer, the practical meaning of these provisions is that RERA is not just an advisory body. There are enforcement teeth behind it as well. Today, RERA's importance is visible not only in books, but also in numbers. According to the official meeting record connected with the ministry from September 2025, by the 1st of September 2025, more than 1.5 lakh projects and 1 lakh agents had been registered across the country, and more than 1.5 lakh complaints had been disposed of. The same official record also stated that, except for Nagaland, all states and UTs had notified RERA rules and established regulatory authorities. This means RERA is no longer some early experimental law. It has become a major regulatory pillar of the Indian real estate ecosystem. For the buyer, the message is clear. This law is not theory anymore. It is an active system, and knowing how to use it is just as important as knowing loan eligibility. Now the most practical question. If you are going to buy property, what real benefit does RERA give you? First, the chance to verify project status. Second, the chance to cross-check the builder's commitments through public disclosures. Third, protection from paying a large amount without a proper agreement. Fourth, the shield of buyer consent against major changes in the approved plan. Fifth, legal remedy in case of delays and defects. Sixth, a complaint mechanism and the path to the state authority. And the biggest thing, now the buyer does not have only a brochure, but also the law. Risk in the property market has not vanished, but there is now a world of difference between an informed buyer and an unprotected buyer. This difference itself is RERA's biggest success. But one thing must be understood honestly. RERA is not a magic wand. Even a registered project can get delayed. Litigation can still happen. Quality issues can arise. And it is not necessary that every dispute will end in the buyer's favor. So see RERA as a safety shield, not blind trust. Before buying property, check the project registration number on the state RERA portal. See the approvals and promised timeline. Understand the carpet area and sale terms. Do not sign the agreement for sale without reading it. Look at the payment schedule in relation to loan sanction and construction progress, and match every major claim in the brochure with portal disclosures. The law is with you, but the law helps only when the buyer is also alert. In the end, the matter is very simple. Buying a house, shop, or plot is not just a transaction. It is often the biggest financial commitment of a person's life. In such a commitment, if the buyer moves only on emotion, urgency, and sales pressure, loss is certain. But if the buyer moves by understanding RERA, then at least the game becomes equal. That is the real strength of this law. It does not make the builder a villain and the buyer a hero, but brings both within the boundary of rules. And in real estate, the biggest relief is exactly this, that the market should run not on promises, but on rules. RERA is India's biggest step in that direction. If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies.